Hello. Once again, it's November 14th. My name is Greg Benevent. As ever, I'm glad to be joined by Belal Hamideh. Belal, how you doing this morning?
Great as ever, Greg. How you doing this morning?
Oh man, I am hanging in. I always feel underdressed. You come in the nice sport coat. I wear the polo shirt, but I think formal enough here for Saturday morning. Hopefully, we've got some questions that came in. I'd love to ask them for you if you're ready for them there, Bilal.
Ready to go. I'll do my
Well,
best to answer everyone's questions. And, we do this every couple weeks to
mhm.
provide free advice to whoever has legal questions regarding car crashes, work injuries, employment disputes with employers, maybe about wages owed. Maybe you were fired and you think it was illegal. Any questions that you have for us, you could just leave on our Belal Hamideh Law Facebook page, and we'll write it down and make sure to get it answered for you. I believe we have about 6 questions for this podcast, so go
That's
ahead,
correct.
shoot number one.
Sure. Perfect. Okay. Well, this first question, I believe, comes from Sharif, and the question, it's a good question. Can I get fired for getting injured at work?
Right. So this is a concern that a lot of people have when they get injured. They don't want to report the injury because they think their supervisor is going to get upset and they're going to find out some way to fire them. Luckily, in California, California provides one of the best laws that protect employees in
Mhm.
all aspects of their job, including work injuries and protection of their job from getting fired. Now, California is an at will employment state, which means that you can be fired at any time, but it cannot
Mhm.
be for an illegal reason. If you're part of a protected class of people, you cannot get fired for being in that class. So, one of the protected class of people is disabled persons. A disability is any injury that has any type of limitation on your day to day activities. So, it could be something very minor. Now, the employer, when an employee gets injured, the employer has a legal obligation to provide reasonable accommodations. So they cannot just fire you. They have to give you a reasonable amount of time to heal up and get back to work. If you aren't healing up, they have to engage in the interactive process with the employee to determine if there's another type of job within the company that they can do. The employer literally has to sit down with the employee and figure out how are we going to keep you as an employee in the company. They cannot just get rid of you. If they do that, you can sue for wrongful termination under FIHA, which is the Fair Employment and Housing Authority, and you can sue for pain and suffering, you can sue for loss of earnings, and you can get attorney fees at an hourly rate. So employers are becoming, hopefully, they understand the law better and they follow it, and that they don't fire injured workers, illegally. If you were terminated after having an injury, feel free to give me a call and we could talk about it for a couple minutes.
Oh, that's great. Hopefully, you're right that employers understand that you have to treat these employees the right way. That was great. Okay, our second question comes from Amir. What if I had an injury from a previous job and I re-injured myself at my new job? Who is liable? I didn't pursue my prior employer for the first injury.
Right. So you can have a workers' comp claim for all work injuries. You can have one for the first one and you can have one for the second one. There is
Mm,
no limitation. If you have an injury before, that means you can't sue for an injury after. Each
mm,
injury can be a recovery for in the workers' compensation arena. And I've had clients that have sustained multiple injuries, either with the same employer or with different employers, and they do have a right to pursue those claims. There may be some apportionment of the permanent injury. For example, if you have a shoulder injury and it was already injured and it got aggravated at the new job, there may be some apportionment of the case value to the first injury, which you can
mm.
pursue, and there may be some apportionment to the case value of the second injury. So it may be worth a little less, but you can still pursue both injuries. And having an injury does not bar you from recovering because you're unlucky and you have multiple injuries.
Mm.
The unluckiness does not prevent you from following your right to pursue workers' comp. for any and all injuries.
Gotcha. No, that's great to hear. That's got to be a relief for somebody that's been having a bad stretch of things. All right, our third question comes from Denia. I believe I'm probably mispronouncing that. And the question is, if I let someone borrow my car, am I responsible if they get into an accident?
Yes, so if you do give somebody permission to borrow your car and
Mm.
they negligently caused an accident, in California, the owner of the vehicle is liable for up to $15,000 uh,
Wow.
for personal injuries towards another person. Also, if you allow somebody to drive your car, the insurance that you have on the car will cover the driver that you allowed permission to drive your car. It acts as if you were the person driving when it comes to the insurance policy limits. So, for example, if I gave you my car and it has a $100,000 liability limit and you negligently injured somebody,
Hmm.
they can collect up to 100,000 from my insurance. And I
Wow.
can also be individually sued for $15,000. But if somebody stole your car and they're driving it without your permission, obviously the $15,000 liability does not arise
Hmm.
and your insurance does not cover that crash. So if somebody stole your car and hit somebody, God forbid, your insurance is not going to pay for that. So the
Mm.
key here is whether or not you gave permission to the person who's driving your car. So definitely be careful to who you give your car to.
Sure. I had no idea about any of that. That's something now I'm thinking back to all the times when I was in high school and college and let someone drive my car and how flirting with danger that really was. I'm glad you answered that question. The next one comes from Amir, and it's if someone slips and falls in a store that has a caution wet floor sign, am I still liable for their injury?
Okay, so I think this is more in regards to a store owner
Hmm.
asking what's their liability when it comes
Makes sense.
to patron coming to the store and getting injured.
Hmm.
Now, as a store owner, you have a responsibility to keep the premises, the store, safe. You
Hmm.
have to, if there's any hazard that you should have known of, you need to take reasonable measures to prevent an injury because of the hazard. So, a common hazard that occurs in grocery stores because you got water bottles on the aisles, you have things that spill over as people walk by, the floor can get wet. Maybe
Hmm.
it's water or a condiment or some type of liquid.
For sure.
um, as a store owner, you have to inspect the store, every reasonable time period, depending on how big the store is. And you
Hmm.
have to maintain a log that says, I inspected this aisle at this time. And you
Hmm.
should have this inspection log, at least every 30 minutes to an hour. Because if
Wow.
you don't, then that's evidence to show that you were not reasonable in the maintenance of your store. But in
Hmm.
this specific instance, where a store owner puts a caution sign, that
Mhm.
is a measure to prevent injury of a hazard they know of. So that's
Mm.
good they took measures, and the measures have to be reasonable to prevent an injury. So you have to place the caution wet floor sign in the correct place. That would be something reasonable. If you put it in the front of the store, trying to alert that there's a wet area in the back, that's not going to protect you from a claim. But if you
Mm.
put the wet caution sign right on top of the wet spot, it's very visible
Mm.
and you're taking reasonable steps to try to dry it quickly and it's open and obvious to the people walking by, then that may help to defeat a slip and fall claim against the store owner. So make sure for store owners to maintain logs every time that they have inspected every aisle, every time they cleaned an aisle, the log with the date and time of the inspection to take reasonable measures to keep your store safe for the customers, and that will help defend against these slip and fall claims.
That's great. I was just struck by as you were speaking how much the details on this really matter. I mean, where you put the sign, the keeping of these logs, all these very specific, detailed actions that mean so much. All right, our next question is if you are in an at fault accident and the passenger with you is injured and your insurance coverage isn't a high limit to cover their bills, what happens?
Okay, so a lot of times you have a passenger in your car. Maybe you made a mistake while you were driving and caused an injury. Even though the passenger is your friend, they make an insurance claim against you. We've seen that happen many times.
Oh, geez.
And then the worry is my insurance going to be enough to cover?
Mm-hmm.
Um, when you hire an attorney, if there's small policy limits for the insurance, what the attorney does is when they make a settlement demand, they do a policy limit settlement demand. So the
Mm.
attorney says, we demand the full insurance policy limits as a settlement for this case. So, for example, if I had a passenger in my car and they were seriously injured, and I only had a 15,000 insurance policy and I didn't have any assets, their attorney would send me a demand, or they would send my insurance company a demand, hey, give us the whole 15,000. If
Mm.
the insurance adjuster does not offer the full 15,000, what that does is it opens the policy limits. So now
Mm.
there effectively is no limit as to how much the passenger can recover against me.
Wow.
And what it is that my insurance company acted in bad faith and left the possibility open for the case to go to trial, to go to verdict, and to get a judgment against me that is higher than my insurance policy limits. So
Oh,
when they act
jeez.
in bad faith and do that, I, as the driver, the negligent driver, can then sue my insurance company for bad faith for the full amount of the verdict against me. Um,
Hmm.
so as long as your insurance company offers the full policy limits of your insurance and you have no assets and sign a declaration of no assets, I wouldn't be overly concerned about individual liability for an injury against the passenger.
That's just amazing. Just that little thing can open that up in such a high way. That was very detailed. That was very helpful. Okay, our final question, the sixth question, comes from Mohammed, and the question is: can I handle my case myself, or should I get an attorney?
So if you've sustained an injury, I would always recommend to get an attorney.
Mm-hmm.
We attorneys in this area are not like others that charge by the hour. We charge a contingency fee, which means our fee is contingent upon winning your claim. So the clients, they don't have anything to lose. If there is a recovery for their injuries, our fee comes out of the settlement, and then they get their medical bills paid through the settlement, and then they receive a net recovery. If they try to handle the claim themselves and they start to negotiate with insurance companies or their attorneys, their job is to pay the least amount possible, and they don't want you to get an attorney because they
Mm-hmm.
know you're more likely to make a bigger recovery of money. So if they have lawyers, you should have a lawyer as well. So I always recommend for people to hire an attorney if there's a claim. I've had cases where, for example, I had a workers' comp case where someone came to me and the offer was very small, and then I was able to get them about 7 to 8 times more, and they were very happy with that, obviously. And if you, as an individual, are trying to negotiate the claim yourself, and you get offers, and you're in a range of money that's small when you're going back and forth, that initial settlement negotiation may anchor down the value
Mm.
of the claim, and it may give the insurance adjuster the thought that anything above this range is unreasonable. So you're
Oh,
making it
jeez.
more difficult for the lawyer who gets in afterwards,
Mm.
because now they have to kind of dig the case out of a hole.
Mm.
So, I mean, if you sustain a minor injury that you don't really need medical treatment, you could probably just resolve the claim on your own. If you sustain a more serious injury where you need continuing medical treatment, I definitely recommend to hire an attorney.
No, that's very well said. I mean, it's your health, it's your life. You'd want an expert there to be alongside you to make sure you come out of that as well as possible. That makes so much sense. Well, Bilal, that's the questions we had today. Is there anything else that you'd like to say to the people while we're live on Facebook?
Just thank you for watching, and don't be shy to ask questions. I enjoy talking about the law and providing information to anyone that I can. We all need to be educated on the law. It's a big part of our life, and try to contribute a little bit of your time to learning about it, to defend yourself and to know your rights in the unfortunate event of a car crash, of a work injury, or of an employment dispute. You can leave the questions to me on my personal Facebook, Belal Hamideh, or you can leave it on the Belal Hamideh Law business page. And hope to see you everyone again in a couple weeks on Saturday, 11 a.m. and wish everybody a safe weekend.
All right. Well, that says it better than I could. Ladies and gentlemen, on behalf of the page here, my name is Greg Benevent. Take it easy and have a good weekend.
Take care, everybody.